everybody. So we are going to waste no time and go ahead and get started today. I'm Melissa Brandon with Startup Prize, and joining me today is Kat Rito. But first, before we get started, I just want to do a quick shout out and thank you to our sponsors, because without them, we would not be able to do things like this. And we truly appreciate their support, and they are what makes this happen. So Startup Prize Focus on Health is presented by the Prize Foundation and Louisiana Economic Development, with generous support from the Anderson family, Blue Cross and Blue Shield of Louisiana, Business First Bank, Caddo Management, Caddo Parish Commission, Chaff and Associates, City of Shreveport, the Greater Bossier Economic Development Foundation, Hurd McElroy and Vestal LLC, Kallenberg Phillips Family Investments, Heidi and Gregory Kallenberg, LSU Health Shreveport, North Louisiana Economic Partnership, and Oshner LSU Health Shreveport. Thank you to all of our sponsors, and thank you to Kat Rito for joining us today. Hey, Kat.
Hey, Melissa. Thanks so much for having me back.
We are thrilled to have you here, and I am very excited about our topic today. I know we were talking about how sometimes it's kind of taken for granted or overlooked. Before we delve into those founders agreements, I'm wondering if you could maybe tell us a little bit about yourself, give us a little quick bio, quick background, and how you got involved with Startup Prize.
Absolutely. So I am a partner at the law firm Walnut Kirsch Davies down in New Orleans. And for about 20 years, I've worked in various industries, particularly healthcare, and a little bit in the restaurant industry, dealing with startups, risk management, and sort of the whole evolution of a company, a little bit of bankruptcy, but that's not fun, so we won't talk about that. But I've got involved in this through Mark Newberg and Greg, and I've worked one-on-one with some of the Startup Prize's past applicants, some of their past winners in a pro bono context. I've also worked and advised people at the events themselves on issues relating to contract agreements, bioethical issues, especially in the healthcare field that we see, emerging markets, and some of the licensing and credentialing issues that healthcare companies come across, not just FDA regulations, but on employment side and marketing. I am really excited today because I think one of the contracts that everyone forgets about is the Founders Agreement, which in a lot of ways is the most important contract that a startup can have.
Well, first of all, when we first started talking about doing this webinar, I loved the comparison of a founder's agreement to a prenup. It just like stuck in my head. And as we were talking about it, it really kind of made me almost think about like a marriage. The analogy makes so much sense. So I'm wondering, kind of using that as a framework, if you could maybe tell us exactly what a founder's agreement is and why it is so important for startups and early stages businesses.
So the Founders Agreement is the contract between the parties that, in theory, in a perfect world, everybody enters into really before the company is even off the ground, before you filed for your LLC or your articles of incorporation. When you're sitting in your friend's basement coming up with the idea for your company, you should do the Founders Agreement. And this is sort of why it's like a prenup. It is the agreement you come to before a relationship is fully consummated. And sort of, I talk about it, a business is a marriage in a lot of ways. I joke at my law firm, I spend more time with my partners and my clients than I do my own family, which is maybe sad, but
like we have her like work husband, work wife.
Exactly. Exactly. We have these terms for a reason, because it's very, this is who you're spending and building your life with. And here it's more of a professional context, but it's the same thing. So you want to make sure when you're forming a company that your values align, that your goals align, that everybody who's coming to bring something to the table is able to contribute the things that they're promising. And so the Founders Agreement is slightly different than the Articles of Incorporation or an operating agreement because it's much more amorphous. You're not necessarily going to have the same information in it, but it has some almost baseline common sense stuff that you wouldn't necessarily think about until something blows up on the back end. So it's one of those.
Yeah, I mean,
it
happens.
It does. And it's one of those contracts that doesn't matter until you need it. And then if you don't have it, it can be deeply problematic.
Mhm.
Um, so what it should outline overall is each party's obligation. When I say party, I mean, a founder, each founder's obligations to the company, the founder's obligations to each other, and then the general rights and interests that each founder is going to get in the company. And, we think about things in terms of ownership, but when we're talking about healthcare or tech, we also have to think about things like intellectual property and data and these other things that are deeply valuable that, you don't necessarily see in other industries, especially.
Mhm.
And you want to have just a base outline in the founders agreement. It's not going to be hyper specific as to day-to-day operations. That's what the operating agreement's for. It's not going to
Mhm.
talk about some other relationships with third parties because that's what those contracts are for. And,
Okay.
I know I've talked about it with you and with Startup Prize and some other events we've done, but specifically the founders agreement is it's the spine and it's also the heart of the company. And it is the agreement that everything else builds off of. And it is deeply important and intimate, really, to everybody who's starting the company. Um, and
Well, I
it's,
wonder. Oh, sorry.
hmm?
Go
No,
ahead.
no, I don't know what I was going to say.
Well, I'm wondering then for this really important document, if maybe we could kind of break down like what are like typical things that you would see in it, or, if we're speaking to your point, like talking about like health or tech related founders agreement companies that founders are working to create an agreement for, if there might be even something specific to those. But maybe like we could talk with like broad general things first, like what would be in your founders agreement.
Yeah. So let's sort of talk about, I think the best way to break that down is to talk about the things you need to think about when you're drafting the founders agreement. And
Mm-hmm.
then, I'll put my attorney hat on with the caveat that I'm not giving any legal advice to anybody, but just offering starting points to people who might be interested in founders agreements as to the things that they should just sort of think about on their own. Um,
Disclaimer noted.
yes, disclaimer noted. So, like we said, the founders agreement, the best way to do it is before a company started or in its very early stages. I like to tell people, when you're starting to work on your pitch deck, whether, for whatever that might be, that's when you need to think about the founders agreement. Think about those documents together. It's something when you're saying, this is my company, this is the money I want, this is what we're going to do to save the world. Great. How are you getting there? Who's going to get you there?
Mm-hmm.
So think about those things sort of in tandem. Obviously, if there is no founders agreement, it can always be done or written up retroactively if you don't have that any sort of document in place. Um, and then, just getting started, the founders need to get very open and vulnerable and honest with each other. What are their personal goals in starting this company? Honestly, in healthcare, we see a lot of very unique goals that you might not see in other industries because a lot of people involved in healthcare, their motivations aren't just making $1 billion, but maybe it's deeply rooted in, social justice. Maybe it's deeply rooted in, you know, a niche product that's targeted to a very specific minority patient population. Um, so you need to think about what do you actually care about when you come in as a founder and you're bringing something to the table. We see a lot of things break down where somebody maybe with who comes to the table with the IP cares more about the target population than the capital investor. So you need to discuss early on how much of something is going to matter. Is this something where we're here to make $1 million? Is this something where we want to just patent and license an agreement and send it out into the universe? Is this something that's near and dear to our hearts where we want to save the world and we don't care if we live, in each other's basements for the rest of our lives because we're going to invest everything into the company. And,
Mm-hmm.
it sounds kind of silly, but people come in with very different motivations and very different things that they want to take away from the company that they're forming. And so it's important to be honest and say, look, I'll give you $1 million, but we're going to do X, Y, and Z with whatever you create, co-founder, or, we just want to try and eradicate this issue. We have other jobs. Everything we build is going to be reinvested in solving this problem.
Mm-hmm.
And
Yeah.
so if those points don't align, then you probably shouldn't be starting a company together at all. I think the last stat I saw was that 65 to 70% of companies for startups actually dissolve not so much out of economic issues and financial issues down the road, but because of disagreements amongst the founders. So if you have a
Wow.
great idea, make sure you have the right team. And these aren't things we think about when we're necessarily starting a company, but come to play earlier. So the sooner you identify those issues and address them, the better. Um,
You know,
you know,
honestly, what you're saying, sorry,
okay.
just takes me back to our webinar from last month, actually. I had the chance to sit down with Mark Newberg, and he talked a lot about a North Star and like finding that kind of vision, that guiding post that's going to lead your
Mhm.
company. And it really similar, I think, to what you're talking about is like that early stage is really determining like those what founders are in agreement with, like what the contingency plan is if things go sideways.
Mhm.
But really having that vision early on to kind of say, these are our priorities, these aren't, or this is
Right.
where the focus is.
Yeah. And so, once you kind of figure that out, you also have to look at, what is each founder going to just invest, so to speak, in the company? Are they,
Mhm.
the tech, expert with, the specialized knowledge and skill set to run tests or develop prototypes? Is it a partner who's more, or founder who's more of a sweat equity person who's going to do some of the day-to-day grunt work? Is it somebody who doesn't have time or the intellectual capital to work on building a project, but they've got access to liquid assets and capital that they can invest in? These are all obviously very valued members of any founding partnership, but you also need to think about I really articulating what everybody's going to bring. Um,
Mhm.
and being clear in that. If someone says, "Oh, I can totally build a prototype," great. Can you actually build the prototype we're talking about? Do you know how
Mhm.
to run and review the medical tests and data that this idea is going to need? Very
Mhm.
clearly talk about what you can and can't do. Um, the last thing you want is someone who's claiming to be a founder in a tech or a health startup, and then they kind of roll off because maybe they didn't have the data you needed, somebody else rolled on, but then 10 years down the road your company sells for $500 million, and that original founder who actually wasn't competent to be in the founder as a group and you
Mhm.
thought left says, "Oh no, I have an email from 2024 that says I'm a founder, where's my share of this company?" And
Right.
it sounds far-fetched, and we can talk about it, the Snapchat disagreement. It's some frat brothers are drinking and talking about sexting, and they come up with this great, wonderful idea.
Sure.
And one of the original founders who did have, Reggie Brown did kind of have his hands in it. He helped with the patents, but he had another job, and the other guys kind of ran with it. And then all of a sudden they're telling him, "Oh no, you were never part of this." They didn't have a founders agreement. They didn't
Mhm.
have an understanding of who's doing what and who's involved in it and who has a stake in this company, be it ownership or equity or however else you want to articulate it.
Mhm. So it
Um,
sounds
so,
like, well, I
hmm?
was just gonna say, it sounds like, first and foremost, it's, who are your founders or and co-founders? What type, like, what are their roles and responsibilities? Like, how are they fitting into the company? And then I would assume also like there's going to be talk about compensation or ownership, all of that.
Yes. Yeah. So the big things I tell people for a founders agreement, I want to see a mission statement, which,
Okay.
a nod a bit to Mark's North Star project. What are we here to do?
Yep.
What's the business concept? We know what we're here to do. How are we going to do it? Is the business going to be building an app? Is the business going to be a non-invasive test? Is it a medical product? Is it, just some sort of communication platform?
Hmm.
We can all say we want to cure cancer. What does that mean? It means something very different for the type of cancer, for the people involved. Articulate that, know what you're actually doing. And that can also be very important down the road if there's a disagreement as to what belongs to the company. We're talking about IP, or if one of the founders has another idea for another company, does it fall under the umbrella of, your other idea, which is great, oh, it belongs to our company too. So that's something that founders need to talk about too, is how far out is the business concept actually going to be for us? What's the business name? I know that sounds kind of silly, but if you're going to start fighting over a company down the road, you need to know what it is again that you may have a
No,
dispute over.
probably a very good good point. Get that name in.
Yeah, well, even the names of all founders. I mean, like you can look at, you know, so many agreements, Facebook, obviously a lot of the social media apps are where we see these problems. And I joke kind of facetiously, it's because they're college kids and they're not thinking about it.
Mhm.
You're like, oh, this is a great idea, let's
Well,
do it. Who's in the
well, and also
room?
a lot of times I think people tend to found companies with friends or people that they trust and like feel really
Yeah.
close with. There's like a great synergy. So you're just like, just kind of like when you're getting married, it's like, of course, like we're good. We know each other. We're good. We got
Yeah, we'll
this.
never hurt each
We have the
other.
same goals. Like I respect you, and
Yeah, I'll
then
always take care of you. Famous last words.
right? But in addition, I kind of like, so we've talked about kind of, roles, mission.
Mhm.
What else should we be? I mean, like you had spoken to like IP, like how that it may be like who
Yeah,
owns it or how it.
yeah. So for IP is, as a lawyer, it's my biggest headache because it's such an amorphous term, but it's the one that it's the biggest fight, right? What is IP? Is it going to be a tangible, good? Is it going to be whatever the prototype is? Is it the idea itself? And if it's the idea itself, again, then is it all the sub ideas?
Mhm.
Is the IP anything you develop on company property? I know, just to give a very, very vague example, I had a college friend that was looking to get a job with the NSA, but in their contract, it said that anything you develop while you're working here belongs to us. And he passed on that and started his own company.
Yeah.
But, if that can be an issue with any company. You know, if I've got a great idea and someone says, oh, you said you were working 100% on our company under this founders agreement, then if you said all of my work is going to go into this company, all of your work includes this great side project. So there needs to be a clear delineation of what is and isn't within the company's framework. Because we all have those people that hyper focus on one thing, and we all know those people that can work on 30 things at once.
Mhm.
So, what is going into the foundation bucket for this company as far as goals and work product? And as the company evolves, if you're working on, some sort of medical test and you work your way up and you're testing, a medication, for example, on patients, you're going to have data sets. That has an inherent value, even if your company fails,
Mhm.
because you can sell that data and that information to other companies. Who's going to own that? Is it going to be specific to the founder that did all the work? Is it going to be an asset that the company owns? Um, those are the sorts of things that you need to think through it's really a philosophical exercise, but those are the things that need to be addressed early on before anything even happens. And, sort of dovetailing to that, you also have to think about ownership allocation of the company. And this kind of goes into operating agreement land too, and sometimes shareholder agreement land. I don't want to go too far into those in this
Right.
talk, but who's going to own the company? Who's going to get what percentage? You know, it doesn't have to be 50-50 or equal split. And there's no answer to that. What it should be, it comes down to fundamental fairness. And this is especially true if you don't have clear concepts, because what a court will look to, if y'all get a huge fight and this ends up in litigation, a court's going to say what's fair and equitable if we
Mhm.
can't tell from the contract itself who should get what. Um, Maybe they'll split it 50-50, maybe it'll go 75-25 in favor um, of the tech founder because he did all the work. You
Mhm.
really just don't know. So that's something to think about fairly too, sort of like in a marriage, you know,
Right.
how much is somebody going to get if the divorce happens 30 years down the road, but somebody changed their career goals based on, oh, I'm going to be in this venture.
Right. Well, and also, I mean, to your point, it's like right now, like this is the time to do it while things are
Mhm.
good, while that
Yeah,
relationship is still good. It's like having that plan for if things fall apart or if just someone has a change of heart, right? I mean, like we all know
exactly.
life has twists and turns, and sometimes you have to step away from an opportunity. Like I would assume there needs to be like things about like if a founder leaves the company or if or maybe even like ideas for like if are we gonna like keep building this or are we gonna exit? Like,
Right. Or, to stick with, we'll pick on Snapchat today.
you
You
okay.
know, why not? Everybody knows
Yeah,
them.
sure. Uh-huh.
Um, Snapchat, Reggie Brown, I think when he graduated, he was the one that took a job elsewhere. So he did kind of phase out. He was still a founder. There's a reason they settled for a very large number.
Mhm.
Um, but he had left. And that's the sort of thing, best practices, I would say you should have had a founder's agreement up front. And then you should have, if somebody leaves the company or takes on less of a role, how does that change their ownership interest if the other two take the company and run and grow it into $1 billion asset?
Yeah.
How do you fairly compensate somebody? And again,
Mhm.
these are things you can talk to, because we all have money for consultants at the start of a company, right?
Right.
These are things that, maybe you should consult, an economic expert or an attorney and say, hey, this is about to happen. How do we deal with it? Or how should we
Mhm.
consider dealing with it? Um, and things do change. People get sick. People say, this is getting too big for me. I don't really want to do it. Um, you should talk about how do we remove somebody as a founder? How will that work out? Um, there should be buyout provisions. There should be rights of first refusal if there is value to the company when they come out. Usually things like assets and liabilities are handled on the operating agreement side of things because, it's an entity that has the liabilities and not the founding individual owners. That's a whole other conversation. But just how do you remove yourself as from being a founder? What's the valuation if your contributions to the company
Sure.
weren't in cash, if you were a sweat
Mhm.
equity or an IP founder? Those are
Mhm.
things that you need to try and quantify amongst yourselves so that if somebody leaves, you know what their value is at that. When you clock their exit, you know what their value was within the organization.
Yeah. Well, I mean, it kind of takes me into like thinking about like vesting, like
Mhm.
is that something that, people should consider writing into a founder's agreement? Like, does that
Yes,
kind of help provide some guardrails maybe or
it does. It's helpful for a couple of reasons. You don't want hard
maybe define
line.
it just in case. I realized we didn't even talk about what vesting is, but maybe just give a quick definition. I apologize.
Okay. So for the purposes of the founders agreement, we would talk about when somebody's interest in a company vests. When have you put in enough that you can get out what you're claiming your value, your ownership stake is? I like to use the example of, say you have somebody who's sort of the sweat equity, founder of the company. They don't have a penny to put in, but they have the IP know-how to say, I can build out, the app prototype.
Hmm.
You would argue there that maybe the founders agreement should say IP founders' interest would vest when the prototype is completed, or you would put in benchmarks. And that
Hmm.
kind of
Oh, I like
protects
that. Yeah.
everybody because you don't want the guy who's, the founder with all the money saying, okay, well, I'm splitting this 50-50 with you. And then, the IP guy does nothing. You want to
Hmm.
kind of let everybody have some skin in the game. Investing is a good benchmark for that to happen because you can say, this is your ownership interest. And then as other benchmarks are hit, it reallocates amongst all of the founders in a
Yeah.
way that seems kind of fair and equitable.
It's really smart. So you could have like multiple stages,
Mhm.
and just base it on different benchmarks for the company rather than like time. It's like, well, when we hit this milestone, this happens that triggers this. And when we hit this milestone, these items are kind of triggered. Do you ever?
Absolutely. And I've seen vesting ownership example, for example, on the capital investor side of the founders where, their investment comes into once I put X amount of money into the company, then I will have this much percentage. So that can cut both ways.
Mm-hmm.
And I think it intimidates people to think about this because you can really set it up however you want. That's the beauty of contract law in the United States.
Mm-hmm.
So long as it's fair and reasonable, most courts will uphold the agreements that you have come to. But it also lets you personalize how you want your agreement to be based on the people involved, again, the motivators, what you're trying to accomplish.
Yeah.
So the idea, is to be thoughtful and really think through what is this going to look like as the company evolves. It's a good thought exercise.
Mm-hmm. Yeah, it really seems like it. Is this something that you, I don't know, like living document maybe is like a little too open,
It's
but
a
like,
living document.
okay, well then yes. Okay,
You
then
nailed it. Um,
hey. I mean, like how
so
often would you like recommend like just kind of checking in or, you know?
so I always tell people, when you do the first founders agreement, it needs to be signed and dated by all the parties. If you want to make it a little more bulletproof, execute it in front of a notary because then it's an authentic document. Like always, I don't know if you've seen the movie, was it Knives Out the Glass Onion?
Oh yeah.
Yeah, where Andy's like, I can prove ownership. I have a cocktail napkin. That's
Yeah.
like a dagger to my attorney heart because it doesn't actually say anything. You know,
Mhm.
there's there's no proof that who was involved. It doesn't say when it was dated. You could make the napkin yourself after the fact and be like, here it is, it was my idea.
Mhm.
Um, if something's notarized, and obviously you don't have to have it, but it's messier and more expensive if you can't prove through a notarized authentic document that this is the agreement we've all reached.
Mhm.
Um, it just helps have all that. And then that's your starting agreement, and that's sort of the starting the clock. This is what our founders agreement is. I tell companies, especially if there's a lot of, well, I tell them generally every year, get
Mhm.
out the founders agreement, and just use it to kind of rehash as a financial time, emotional check-in. Where am I on this company? Am I ready to walk away? Is so and so not meeting their goals? Maybe we need to talk about if they stay on. Um, but the founders agreement is really just the founders agreement. Once people are hired as employees or more people come on, that's where other agreements come into place. But, if we're worried about founder ownership in terms of, again, like a Snapchat, where maybe they're going to relinquish their ownership in the company because they want to move away. Do they want to sell their ownership stake? It's a good way to sort of definitively say when people are in and out of the company.
Mhm. Got it.
Because,
Yeah.
as an app becomes or a medical device becomes more profitable, you want to know when did somebody clock out and roll off and they're no
Mhm.
longer an owner. Because remember, the founders are the founding owners. So
Right.
even as people come on as shareholders or something else, if there's that underlying document that says John Doe is a founder with 30% interest in the company,
Yeah.
maybe you want to take his 30% interest because he's not involved, see if you can buy it off of him and, sell it to a new investor, sell it to another stakeholder, use the equity for negotiating something. That's a good time to sort of check in on where everybody is. Especially in these companies that are very amorphous because so many people might be involved in the startup ideas.
Got it.
Um,
Well, so let's say you're 2, 3 years into building your company with
mhm.
your bestie co-founder. Um, and you don't have a founder's agreement in place. I know you say it's never too late, right? But
Yeah.
what would be like that? Like, ugh, okay, we haven't done this yet. Like, where would you have folks start? Like,
Um,
do they bring
and
in like someone to kind of help them navigate it? Like, is it worth bringing in someone to kind of help set it up, like consult, or is it better to just see what you can accomplish on your own?
I say it's always good to have somebody consult. I know in entrepreneur land, we can't always afford that, which is a problem. In a perfect world, we'd have, a CPA and a lawyer and a patent lawyer and all these people doing all these things for free to help
Sure.
us and bulletproof our company. It's never too late to do it. And, there's no state that requires a founder's agreement. This is just more of a document that protects all the initial founders and parties involved in the startup as it evolves to make sure their interests are in it. I mean, we've seen, you can look up any of this. I'm sure most of the audience will know, there were disputes with Apple. Let's talk about, we're not going to talk about it because it'll take a whole other seminar, but Facebook, you know, so many major companies ended up with back end $100 million disputes, largely because they didn't have those founders agreements in place that would help you understand who actually owns this company, who owns what portion of this company. If a company is going to break down, who's going to get the IP, who's going to get the data sets, does somebody get to keep the trademark? Decide that up front before there's a dispute down the road and everybody has to lawyer up and there's no clear answer to those questions. So all you're going to do is pay me a lot of money, and that's awesome for me, but for nobody else.
Yeah.
But if there's a clear argument, a clear article that says you get this, you have to buy this out if you want to use the data sets, then there's something that's already in place. But if you want to negotiate around that, the value that everybody's coming to the table with.
Just kind of sets those boundaries and kind of provides that security
Mhm.
for all your initial founders. I know we're getting kind of close to the end, so I do want to let everyone know, like, feel free, like, if you have a question, drop it in chat. I'm happy to like help pass those along. I'm wondering if there's, I don't know, like a better way to really define those roles and responsibilities. Is there like a, I don't know, like, do you kind of think about it in terms of like buckets? Do you think about it in terms of I'm sorry, I guess that's not a great, I'm just trying to think about like how to really define out those roles, but I think
Um,
funny now.
a lot of people model off, the corporate world. They'll say, I'll be the COO,
Hmm.
the boots on the ground person who's going to organize everything and make the phone calls and negotiate contracts. Then someone will be the chief,
Kind of
technical
think of it as
officer.
your C-suite, but like you're just taking on multiple C's.
Yeah, because that's, when we sit there as a population, we understand on a superficial level who the CEO is. They make the decisions. Who the
Hmm.
CEO is. They kind of make everything happen. The
Hmm.
chief medical officer. So people will sort of, I have found, give themselves titles based on that. Or if
Hmm.
you don't really know, because honestly, like a CMO is a thing and it's not always what we think it
Right.
is.
Hmm.
The best thing to do is just put in a checklist and say, I'm responsible for these issues in the company.
Hmm.
I'm responsible for doing this. I'm responsible for filing the articles of incorporation with the state, making sure all of our compliance documents are in order. And that's also really good because as a company's building and gaining speed, and there are even more moving parts, you want to know who's doing what. Again, this is a relationship. So, I mean, you joke in a prenup, you don't necessarily say who's folding the laundry, but you
Hmm.
might say this person is going to be responsible for most of the household services because the other partner does not work in the home. Does
Hmm.
that make sense?
Yeah,
You
absolutely. Just
might,
kind of filling out where people's spheres of
it's
responsibility.
expectation management. And it also gives everyone else a chance to be like, hey, you need to finish this benchmark testing. Where's the prototype that we thought would have been built within 6 months? Are the patent documents lined up? The thing that
Hmm.
you said you would do, you don't have to have a formal title written out for that. But if John Doe is in charge of the patent application, you can then ask him clearly, hey, we agreed you were doing this. Where is it? And it makes it less confrontational as well,
Hmm.
because there's an objective document that everybody's supposed to kind of be following.
Right. Well, yeah, no, and I can absolutely imagine a scenario where someone's like, "Oh, I thought you were taking care of that," because
In the best
in
of
the early company, there
circumstances.
are so many hats that you're wearing. You aren't just
Mhm.
like in that little role right here. You're probably working on your financials, and you might also be doing some marketing, and you might also be, searching for funding, and at the same time, you might also be, working on IP for the company. So to your
Yeah.
point,
And yeah, and
finding.
multiple people can be doing that. I mean, as we all know, everybody in an entrepreneur land has to kind of hustle for money. If I have I won't be at a conference if I'm starting a company and there's an investment opportunity and say, founder's agreement doesn't say I'm doing this. So again, there's this fluidity,
Sure.
and or you could say everybody's responsible for identifying these
Mm-hmm.
opportunities.
Mm-hmm.
But I mean, it can also be for the day-to-day, the operational stuff. Sometimes it's helpful to say, John's doing this, Joaquin's doing this, Stephanie's doing this, because it can also minimize inefficiencies.
Yeah.
If everyone's got a clear carved out role in the chaos of a startup, it can also help you streamline how you're using your resources and your time.
Yeah, I really love that. Well, I'm going to open it up if we have any questions from our audience. I know that there are some of you out there. So feel free to drop a question in the chat if you have any questions for Kat. Kat, I would say like, I know we've talked a lot about Snapchat, but any other kind
Mhm.
of I don't know, unexpected stories. Sometimes it's nice to hear like what people aren't thinking about that have kind of come and got them. Uh, I think a lot of times people are thinking about like, sometimes like who gets paid what or who gets this, but are there things
Yeah.
that like have surprised you or maybe surprised someone that, I wouldn't have even thought that would have been an issue?
I think one thing that we see a lot of, and this is also why a founder's agreement is important, is figuring out the hats because a lot of people don't know what they're doing. And sometimes you have an agreement as a founder, but you're also doing work that would more qualify you as an employee.
Mm-hmm.
And again, there's ownership interest, but then there's also, I worked and did all these things. I should be compensated for that. So
Mm-hmm.
I think, and to use an older example, and this is back in, the like probably like 2012 to 2016. My favorite example of this is the dispute between Adam Carolla, who is like a TV personality, and Donnie Mizrahi, his childhood friend, who is in TV production. Um, Adam Carolla got fired by CBS. He had a big non-compete agreement in his clause. Actually, bookmark. We're going to talk about that in a second. Um,
Oh, okay. Mm-hmm.
and so this is when podcasting was really starting to come up. And Donnie and Adam decide they're going to start a podcast because Kroll was still collecting a paycheck from CBS. There was a non-compete. He couldn't really solicit advertisers, so he couldn't do anything to generate income with this idea. But he and Donnie have been friends forever. Donnie's like, "Look, I got you. I'll put a second mortgage on my house. What's going to go wrong here? It's a great idea."
Uh-huh.
So many things are going to go wrong. Um, But anyway, so the contract expires. All of a sudden, Adam Carolla can start collecting advertising money. They make a ton of money. This is the highest grossing podcast in that era. Um, Carolla had apparently promised Dimes Rahe, look, I'm going to give you 30% stake in this. We're taking this gamble together. I promise you it's going to pay off and we're going to do this together. You know, baby, we're in this marriage forever. I love you. We're
Mm-hmm.
partners. And then you
Mm-hmm.
get divorced, and that's not in writing.
Right.
Well, yeah, at some point, Donnie tells Adam, look, we've been doing this for a couple years. I haven't gotten paid. I need to get something out of this. We're killing
Mm-hmm.
it. And Adam Carolla fires him in an email. Now, what got really messy about this is you can't fire a founder. They're a co-owner.
Mm-hmm.
You can fire an employee. And then Donnie's like, fine. And I'm just giving you a broad
Mm-hmm.
summary of what happened. If I'm an employee, you never paid me, and we've been doing this for years. And if
Mm-hmm.
I'm both, then I have an ownership interest and, a wage or, a benefits claim.
Right.
So as you can imagine, again, these things are great for lawyers. They're bad for all of you. Because, you have all of a sudden 1,000 issues that were never resolved and were
Mm-hmm.
never clearly identified or articulated. Was he an owner? Was
Right.
he an employee? Those are different liabilities for the company when they're compensating him.
Mm-hmm.
And that was never really squared away. And, Donnie Mizrahi said, we weren't lawyers. We're not businessmen. We never put anything in writing.
Mm-hmm.
So how do you resolve that when two people who clearly were founders factually completely disagree on the origin story of the company? They completely disagree with the valuation. And then they disagree with any other, benefits or, um, assets or liabilities that they may have accrued and who's responsible for all of them.
Yeah. I
And
love the comment from Kyla, which says
hmm,
I'm told to prepare for the divorce before the marriage. I mean, but it's kind of like really what these founders agreements are doing. And I know you had mentioned non-competes to like, we're going to circle back to those, a non-compete.
yeah. Yeah, so that's another thing that I like to see in a founder's agreement.
Mhm.
Especially, we kind of talked about people roll off.
Yeah.
You don't want them to roll off with all of your institutional knowledge and use it against you.
Hmm.
So it's really important for there to be, a confidentiality agreement, a non-compete agreement, and a non-disclosure agreement. And those are all very different things, obviously. Confidentiality agreement, what's going to stay privileged and confidential within the company that you can never share with anybody. That kind of goes to the IP. Um, it can also go to disputes. You don't want anybody saying, oh, I worked with them, they're terrible.
Yeah.
Is there going to be some, what information and interactions within your company? And these are also things that you don't necessarily, it can be very fluid. There's no strong legal definition for this. What has to stay within the confines of this company that you have built? Can't
Hmm.
go anywhere else. Um, non-disclosure agreements are also very similar. You don't want to disclose company information. You don't want to disclose interactions between the founders necessarily. Um, what what are people allowed to talk about publicly? Again, this is really important if things go sideways.
Right.
And then a non-compete agreement, again, you don't want somebody who is a founder who rolls off or maybe does get pushed out somehow, being like, okay, great. Nothing's stopping me from building a rival identical company and going after you or going after your client base. So those are also things that you need to kind of think about because, if something goes south, but everybody's still married to the idea, who's going to get to take it?
Hmm. Yeah. Yeah. How does that company dissolve or split apart
Mhm.
fairly? Hmm.
Yeah, and those are things that you might also see in the operating agreement. Every state has different requirements for that. Different business entities have different requirements for the documents that you need to form a company or need to be filed. So it is also very important. Again, like I said, I don't want to go too far into the shareholders agreement or the operating agreements because those are separate discussions. But to
Hmm.
the extent that there's going to be a non-compete clause or a dissolution clause or something to those effects, whatever the agreement is in one document has to be consistent amongst all of them. Because the founders agreement has a dissolution clause, but someone can say, the operating agreement says something slightly different, then you're back in the situation where it's almost he said, she said, and what did we really mean? And
Hmm.
what's the core agreement amongst the founders of the company? And so, these documents are great, but you also need to kind of look at them, even though they're separate as a set, and make
Hmm.
sure that they all have the same rights, responsibilities, and value sets consistently amongst them.
I love that. That's really actually a very good piece of advice to kind of make sure there's consistency throughout these agreements. Well, I know we're kind of getting near the end of our time and I want to respect everyone's. I'm going to throw it out with one last question for you, Kat.
All
I'm
right.
guessing sometimes this can probably be kind of a hard conversation, right? So are
Yeah.
there any tips as people kind of start down this road to kind of, I don't know, start off on the right foot or like make the conversation easier?
I like Kyla's point. You prepare for the divorce before the marriage, prepare for the problems that you can see coming up.
Hmm.
You know,
Oh,
I
that's a,
had,
yeah.
I did a founders agreement for a company several years ago, and one of the founders was pregnant with triplets. And she
Hmm.
was like, I'm going to be able to do X, Y, and Z. And I was like, look, I had one kid. And I guarantee you I could not have done X, Y, and Z with one. Think about what your life is going to look like with three. And can you do all these things? And, she would not have been able to, when she actually thought about the time commitment. And so that was sort of, we laughed about it, but it was sort of a turning point where I said, well, if you're sleep deprived and you got three babies and you can't afford a night nurse because you're doing all these things, how are you going to solve all the problems that are going to come up in this emerging venture that you have? And
Mhm.
it made everybody think about, okay, if she can't do X, Y, and Z, who can then do X, who can do Y, and she can still agree to do Z.
I love that. Yeah, it's almost like kind
And
of predicting the problems that you could foresee happening, or just kind of like trying to
yeah,
like decide like, well, what if this it's like playing the what if game, really. I mean,
it's absolutely the what if game. And I think that's the hardest thing about founders agreements is everybody wants to talk about the things we're going to do because we're going to be successful. Because why would you start a company if you think you can't succeed?
Mhm.
But you need to think about, because statistically speaking, like marriages, a lot of them break apart or they fail. So we need to talk about identifying how is this going to go wrong? And I always tell people, I know we don't like to think about how things will go wrong or if things fall apart, but I said it also kind of forces you to bulletproof, your company mission and your plans. You can say, well, we want to keep working together. Obviously, we wouldn't be here.
Mhm.
How are we going to prevent this from causing a dissolution or, there being $1 million fight over IP and data sets down the road?
Yeah.
It's
No.
a good system to troubleshoot and then think about and this doesn't all go in the document, obviously, but what would we do?
Mhm. I love that. I mean, it's a great way to think about it.
Yeah,
Well, with that, Kat, I think we'll wrap it up for today. For those of you who are here with us today, thanks so much for coming and hanging out. Kat and I will stick around for a little bit afterwards for any last questions. And to all those of you out there, thanks again for tuning in. Kat, you want to go out with a little Viva with me? A little Viva.
sure.
All right, awesome. All
Oh,
right, everyone, we will see you next month. Thank you again. And on the count of three, Kat, a one, a two, a three. Viva la startup.
Viva.
We'll see y'all next time. Thanks again.
Thank you for having me.